All right, we're going to go ahead and get started. Thank you again, everyone, for joining us today. You are going to be participating in the presentation on lease considerations for dry cleaners, COVID-19, and environmental concerns. First of all, I would like to thank our two co-sponsors, Minnesota Cleaners Association and Wisconsin Fabric Care Institute. Huge thank you for getting the word out to your members and your communities. Just a few housekeeping items. We are going to have 1 hour slated for the presentation. That does include a Q&A session at the end. So if you'd like to submit any questions throughout at any point in the presentation, we will cover it at the end, but just please go to your control panel and click on the questions tab, type your question there and hit send. And if you're worried that you might miss anything, there is going to be a recording of the presentation that's going to be sent to all attendees in a forthcoming email. And to get started, I would like to go ahead and introduce our presenters. First off, we have Ethan Geis. Ethan is a member of the real estate and corporate teams at Davis Coulthau. He regularly represents businesses, investors, and management in a wide range of capacities, including development, financing, leasing, and acquisition and disposition of properties. His clients are engaged in projects ranging from office, industrial, retail, to multifamily. Ethan also counsels both well-established businesses and startups with regard to entity selection and formation, governance, regulatory compliance, crisis and succession planning, and commercial contract drafting. Ethan invests the time to understand his clients' business plans and the industries in which they operate so that he can tailor cost-effective solutions to each client's defined objectives. He uses his experience as a former litigator to help anticipate and avoid potential conflicts for his clients proactively. Mr. Andrew Squarowski. With 12 years of legal experience, Andy combines his background as a veteran software developer and small business owner to his technical and scientific focused law practice that includes environmental litigation, e-discovery, complex commercial disputes, and municipal compliance. Andy's environmental litigation work has included representing manufacturers, property owners, farmers, and environmental organizations. We also have Ted Warpinski. With over 30 years of experience, Ted has worked on a wide variety of environmental and litigation cases across Wisconsin. From the early years of Superfund litigation on sites like the Fedrowski Drum Disposal Site in Franklin, Wisconsin, and the Moss American Site in Milwaukee, Ted has been immersed in both legal and technical aspects of environmental law. Ted's litigation practice has grown to include environmental nuisance claims and toxic tort litigation, contract and property disputes, construction defects, insurance coverage litigation, and enforcement actions. Ted also works very closely with the firm's real estate and development lawyers, handling due diligence investigations and environmental permitting. His experience includes addressing real estate deals that involve brownfield issues where the risk of liability for historical contamination is a major consideration. Ted's experience allows him to assist the DK team with understanding and managing these risks. Both Ted and Annie have represented dozens of dry cleaner sites across the state of Wisconsin to address historical site contamination with the Wisconsin DNR, as well as resolving insurance coverage disputes with their insurers. And then last but not least, yours truly, my name is Drew Shields. I am the Director of Dry Cleaning Accounts here at EnviroForensics. I have going on 12 years of account management experience in the environmental consulting industry. I currently serve as the Allied Trade District Committee member on the Dry Cleaning and Laundry Institute Board, as well as serving on the Advisory Council for the Midwest Dry Cleaning and Laundry Institute. I'm also an active member in 14 dry cleaning associations, and my role here at EnviroForensics is to assist clients in securing funding for their projects through historical insurance policies. I will also be your moderator today on this webinar. Without further ado, I'm going to hand it over to Ethan.
Thank you, Drew. Good afternoon, everyone. We're going to cover quite a bit of material here in the next 40 or 45 minutes or so. So going over the discussion outline, it's going to be broken up into two basic parts. First, I'm going to give an overview of lease considerations, whether you're looking at renegotiating a lease or potentially terminating a lease. or considerations for entering into a new lease if you're looking for new premises. I'm going to go over the key lease provisions that have been at issue and litigated here during the COVID-19 pandemic, and particular to dry cleaners. Then we're going to move on to potential strategies for renegotiating your leases, what types of things you may be able to concede in a lease negotiation in exchange for what is typically being asked for by tenants right now in the form of rent abatement or rent deferrals. And then finally, we'll briefly go over legal justifications for a tenant unilaterally attempting to modify or terminate the lease if negotiations don't pan out. And then finally, my colleagues Ted and Andy will go through environmental considerations both during the lease and post termination. So we can go to the next slide. Brief disclaimer, all three of the attorneys on this webinar are practice in Wisconsin and are licensed in Wisconsin only. I understand we have several folks from Illinois and Minnesota that may be on this webinar. So any type of specific legal advice will of course need to be conditioned on a review of the facts and circumstances behind your specific circumstances. Next slide, please. So I want to start out briefly by going through what are the sources of tenants' rights in their leases. There are two basic sources. The first is going to be the landlord-tenant statutory code that all states have promulgated that are going to provide default obligations, rights, and provisions in the commercial context if the parties have not otherwise contracted around them. For commercial leases, unlike residential leases, in commercial leases, most states allow the parties a wide degree of latitude in contracting provisions as they choose. It's a principle called freedom of contract. So you'll see many form leases that are presented to tenants by landlords that are considerably one-sided. But given the fact that most parties are sophisticated business parties, or at least business parties, those provisions are, generally speaking, enforceable, regardless of how heavy-handed they may be. Next slide. There are a few areas in which the parties are not free to contract around. Typically speaking, that's going to be relating to eviction proceedings and whether or not there's any self-help remedies that landlords can pursue. The duty to mitigate after a default by one of the parties. Typically this will be a landlord obligation, especially if we're talking about it in terms of the pandemic. If tenants are failing to pay rent or having trouble having rent come in the door, the duty is then on the landlord to attempt to mitigate any damages after a tenant default. Liabilities to third parties. There's a concept called privity of contract between the two parties, landlord and tenant. While they may be able to allocate risk between themselves, they are not able to shield themselves from liability to third parties based on their actions within the contract. And then finally, duties under environmental regulations or other regulatory schemes, whether that's federal or state, they may impose duties that are not otherwise stated in the lease contract itself. But generally speaking, the state landlord-tenant statutory codes, while there may be provisions that look like they are mandatory, generally speaking, the tenant's rights and obligations are going to be formed based on the lease contract, as the default rules generally can be avoided. Next slide, please. So in reviewing your lease, if circumstances are a bit dire under the pandemic, revenues not coming in as it should, there are several lease provisions that I've had the opportunity to review over the last 10 months. Typically speaking, I represent landlords probably about 75% of the time and tenants about 25% of the time. But the provisions that we are reviewing now under the current economic circumstances are listed on this slide. So the ones to review are going to be whether there are any tenant early termination rights. Again, these will typically be ones that you'll be aware of at the beginning if you've negotiated them. There are some circumstances in which I've seen even landlord forms provide tenant early termination rights that the landlords and tenants didn't negotiate, but were shoved in there from either a prior lease draft, or the form wasn't terribly specific and they didn't take it out from a prior deal. So do review your lease, because the parties that have the freedom to contract. Review your lease and make sure you know what it says. There may be certain circumstances in which there are early termination rights, whether that's a drop in revenue or whether there are co-tenancy provisions. If the premises are at a retail center that aren't being met, there may be certain circumstances in which the tenant can leave the lease early. Certainly the next one, default, cure, and notice. It's important to know what constitutes a default. And is there written notice that the landlord needs to deliver to the tenant in order to create what is otherwise a breach of the contract into a default of the lease obligations? So I've seen plenty of landlords send what they think is effective notice and default to tenants. They're doing it via email, but it's not actually an effective termination or a default notice under the terms of the lease. So put them to their proof if they're doing so. Remedies, this is a section clearly that if rent is hard to come by right now, or it's being difficult and your landlord's not willing to negotiate, you have to know what the landlord's remedies are in the event of a potential tenant default. Was there an acceleration of rent concept? Certain circumstances, upon a default, a landlord can accelerate all future due rent discounted to a present value and attempt to collect that from the tenant. Some courts find that to be an unenforceable provision, but it's certainly one you need to be aware of. Assignment and subletting. Again, if circumstances are such that it may make sense to strategically withdraw from the premises, you need to know whether or not, if you can provide a credit-worthy and sufficient replacement tenant, what's the standard by which the landlord needs to review that? Is it based on the landlord's reasonable discretion, so that if a replacement tenant or an assignee or a subtenant is provided to the landlord, does the landlord have an obligation to review that commercially on a commercially reasonable, standard, or is it within the landlord's sole discretion to accept a new tenant? Force majeure provisions. This is a highly litigated provision in the last 10 months or so since the pandemic began. A force majeure provision is a provision that allocates risk when unforeseen circumstances occur, such as a pandemic, the likes of which we haven't seen in 100 and 115 years. So a force majeure provision will allocate risk between the parties and determine whether or not, if circumstances are so unforeseen and not caused by the tenant, that, for example, a rent obligation is difficult because customers are not showing up at the door, do they have a right then to withhold rent or to abate rent to a certain period, to a certain extent under that provision? Go dark, go dim provisions and anchor tenant provisions and co-tenancy provisions are also ones to look at. These many times supply a possibility for the tenant to lower its operating costs if it doesn't make sense to be open from 8 to 5 Monday through Friday. If governmental restrictions are causing the customer bases not to show up at the door, is there a potential justification here then for the tenant to go dim or to go dark without actually defaulting under the lease? You may have a rent obligation that still comes due, but you may not be defaulted under the lease in that circumstance. So those are certainly some to look through as you're examining your lease. Next slide, please. So then I want to briefly go through a bit of my experience in what we've seen for tenants and landlords renegotiating their lease provisions. Again, first, what I would say is as a tenant, if you're looking at potentially renegotiating your lease, you've got to come to the table appreciating the landlord's situation. I think that will go a long way. Again, the landlord may be willing to potentially renegotiate the lease with you, reduce rent obligations, or come to some alternative arrangement, but the loan agreements that may be in place on the property may prevent that. So it's important to know that there are there are at least in many circumstances another party involved, and that's the lender. And the landlord's covenants and obligations that are due to the lender may prevent amendment or at least require approval of the third party. So I've set forth a couple provisions that are typically found in a loan agreement: debt service coverage ratios, insecurity clauses, and prohibitions against amendment. Those are all things your landlord is going to be looking at as to whether or not the landlord can actually modify your lease, even if it wants to. So next slide, please. Other landlord concerns, I call these soft factors. These aren't the hard factors of rent abatement or rent deferrals or the provisions of the lease, but soft factors are, as a negotiation proceeds, the landlord's going to want several considerations taken. There are going to be several considerations the landlord's going to be looking at, is making sure that there's no non-disclosure or no disclosure to third parties, especially other tenants if it's at a retail center. That can cause an avalanche of negotiations that may not necessarily be favorable to the landlord. Confirmation of financial situation. There's been plenty of tenants have negotiated against who have raised the specter of the COVID-19 pandemic, and yet their financial situation has remained the same or actually improved. So they will probably want documentation if there's going to be any rent abatement, to make sure that in fact that your financials are on the decline. And finally, they want to make sure that you've pursued other avenues, whether that's governmental programs or whether that's making a claim under a business interruption insurance policy. If one is required under the lease, they'll want confirmation of that. Next slide, please. And finally, I'll briefly go over this slide. Again, it's kind of a soft factor as to how you want to approach the negotiation. I think generally speaking, I've seen more of a cooperative approach between landlords and tenants, and I think landlords have been very fair in attempting to negotiate with tenants throughout this pandemic, because I think the entire ecosystem needs to adjust. Landlords, lenders, and tenants all understand that everybody's in this together. But I have been a part of plenty of negotiations in which a tenant or a landlord takes a very adversarial position off the bat in an attempt to railroad the other party by raising certain legal justifications for the end goal that they're attempting to seek. But you'll have to know the person you're about to negotiate with in the landlord's position to know which strategy may be more fruitful. Next provision, or next slide, please. So again, if we're looking at strategies for renegotiating your lease, generally speaking, you're going to be looking for some sort of rent relief, and you have to take into consideration the short-term rent relief that you may be asking for versus the long-term effect on your lease obligations. Because typically speaking, your landlord is going to want some sort of exchange from you for the rent relief, whether that's a term modification. Generally speaking, a longer term is going to be beneficial for a landlord. It's going to be beneficial if they're attempting to sell the property to sell a new buyer on the property. And also they want stability if they're planning on operating that property for a long period of time. However, I have seen in a few circumstances actually a shorter term being negotiated because a landlord thinks that the fair market rent that is currently being paid under the lease is a little bit, or the rent that's being paid is actually lower than fair market rent that they could otherwise get. So again, it's going to be short-term versus long-term considerations from a landlord's perspective. Having below fair market rent is certainly a beneficial thing. The question is whether or not that's able to be paid, and what do you want to exchange in exchange for some rent relief. You have to look at it from a landlord's perspective and attempt to find mutual ground to seek. Next slide, please. So one of the major provisions we've seen negotiated is a modification of the rent structure in itself in an attempt to align the parties' interests. So most leases are going to be a triple net lease in which there's a base rent paid and triple net costs on top of that and utility costs. I have seen and negotiated several leases now in which, at least for a short period of time, whether that's a year or 2 years, there's what we call a percentage rent structure put in place, where there's a lower minimum base rent, and then there's a premium that's paid off over and above that, which is based on the gross revenues or the net revenues of the tenant, so that whatever the landlord is going to be owed is going to be commensurate with what the tenant is actually able to derive in revenue from the premises. The goal being is that whatever the percentage rent, the net revenue to the landlord is going to be based on if the revenues pre-pandemic get to the point in which current rent is paid at a level of the pre-pandemic revenues, that's going to equalize for the landlord. Next slide, please. All right, some of the other considerations here for a potential concession for rent abatement: elimination of tenant option rights or renewal rights. Again, we're looking at this as to what's the short-term benefit in attempting to make sure that the lease and the tenant can remain solvent, and what can you give up for that potentially, and what a landlord might be willing to exchange. In certain circumstances, tenant options or renewal rights are waived by the tenant in exchange for those rent abatements. Guarantees, this is a risky one. This is one I see a lot of landlords requesting, is that if there isn't otherwise a guarantee in place on the lease, a personal guarantee for a corporate or a company tenant, they're requesting, hey, we'll give you a rent abatement or we'll give you a rent deferral. However, we need to make sure that if in fact you do default, there's going to be some personal liability associated with it for the principals behind the company. Again, that's a very risky one. And I think if you're going to potentially negotiate that, you've got to limit it in both scope, time, and the amount of the liability if you're going to potentially try to exchange that. Security deposits, if one isn't otherwise required, I've seen those get required, whether that's presently or in the future, that one's going to be funded. I've seen landlords request that. A landlord lien is simply a security interest in all tenant property. If that's not in place in the lease or by state law as a default, some landlords have been requesting that in exchange for a rent concession. And assignment and subletting. This may be something that tenant may want to bring to a landlord and ask whether or not there can be a modification in which the tenant, if it finds a credit-worthy successor tenant, if they're not able to make a go of it at the premises, can they provide a credit-worthy replacement tenant, and whether or not liability will stop after that assignment or after that sublease. Certainly something to consider. Next slide, please. Finally, other provisions, the last grouping, default, cure, and notice. You may want to re-examine these provisions. Again, the landlord here is gonna be looking at whether or not they can impose a stricter default and default notice provision in exchange for rent, so that if you don't make good on even the lesser amount of a rent concession or the lesser amount of a rent obligation, that they'll be able to recapture their rent obligations in the future. Required insurance, I've seen some landlords request business interruption insurance or certain exclusions from, addendums to the policies in an attempt to provide coverage that if a similar circumstance to the one that we have ongoing right now with the pandemic, if that occurs, that there would be some insurance coverage to supply revenue to the landlord. And finally, force majeure provisions. Again, these are very important provisions for unforeseen circumstances like pandemics, and I see a lot of parties renegotiating these now that an unforeseen circumstance has interrupted the landlord-tenant relationship. Next slide. And then finally, I'm going to conclude my portion here with potential justifications if negotiations are unfruitful. What are the potential justifications for a tenant to unilaterally attempt to modify or terminate either the lease itself or a rent obligation they're under? in the last 6 to 8 months since these cases have been filed, I will say these justifications have been a little bit difficult for tenants to prove and to win on. But because the courts, generally speaking, don't want to relieve the parties of the contractual obligations. But there has been at least a lot of tenants raising these claims in court or in potential demand letters for rent abatement. So I'm going to go through these. They require a close review of the facts and circumstances applicable to your lease, but they're at least available for tenants. Before that, the first thing to not overlook is whether or not you have a contractual right to terminate. Again, we talked about that at the beginning of the presentation. Make sure you know your lease. Make sure you know whether or not there's an early termination. I have seen some in which tenants haven't even been aware of it, but there's if gross revenue threshold, if gross revenue dips below a certain threshold, whether or not a tenant can actually terminate that lease early. And I've seen certain circumstances, tenants being unaware of having that. So make sure you look at your lease and know what it entails. The first doctrine and potential justification for a unilateral modification is what we call frustration of purpose. So this allows a party to a contract to be excused from the performance if an essential purpose of the contract is frustrated due to circumstances that are completely and wholly unforeseen by the parties when they entered the contract, and they're not caused by the party who's attempting to invoke the doctrine. The trouble that tenants have come up against here is what is the essential purpose of the lease contract? Is that the purpose of the contract is to make money at the premises? Is the essential purpose to operate a business? That's what is being litigated in these frustration of purpose cases. Is in some circumstances, landlords are being able to show that it's not the essential purpose of the contract from a tenant's perspective is not actually to make money. It's to be able to occupy the space in exchange for rent. But again, it is certainly something to raise with your landlord, because if governmental restrictions are prohibiting a majority of your operations, that may potentially be cause for invoking a frustration of purpose doctrine, termination or modification of your lease. Next slide, please. The second doctrine is very similar. It's called impossibility or impracticability of contract. Again, you have outside intervening circumstances that were unforeseen by the parties that cause a party's failure to perform. So in this circumstance, generally speaking, a tenant either paying its rent or not being able to operate at full capacity. If that subsequent and intervening force makes it substantially more difficult or costly to render its performance under the contract, or actually impossible, the tenant may have a justification for either reducing rent or, depending on the term of the lease and how much longer there's left on the term, potentially canceling the contract. Again, many courts look at this and they take a very strict interpretation of this. Is it actually impossible for the tenant to pay its rent? And that may require a review of the tenant's circumstance, financial situation. If they have the capacity to pay, even if there's no revenue flowing through the premises, they may still have an obligation to pay the rent. Next slide, please. So in looking at these justifications, some of the landlord counter arguments that we've seen bandied about is what's the actual intervening force here? Is it a direct effect of government restrictions where you actually cannot operate your business, or is it a intermediate force, which is the government restrictions have caused people not to come to the premises and pay good money, but it's actually economic circumstances that are causing you to have difficulty to not pay your rent or be able to pay your rent, as opposed to actually being shut down by the government. The force majeure clause that we've talked about in the lease Most courts take the position that if there's a force majeure clause that plausibly describes the situation in which we're in, a pandemic, an act of God type scenario, that if a force majeure provision is in your lease, that has operated to allocate risk for unforeseen circumstances. But again, it's going to depend on the actual language of the lease. And finally, in most leases that we look at, there's what we call an independent rent covenant, which specifically says no matter what happens, tenant has an independent covenant to pay rent regardless of any defaults by landlord or any unforeseen circumstances. That provision has dubious enforceability, but it's certainly one that tenants will have to contend with. Finally, there is a final justification for potentially modifying your lease unilaterally, and that's if your landlord is failing to fulfill its obligations under the lease, whether that may be deferred common area maintenance or services, or lessened common area maintenances and services. If the landlord is not fulfilling its total obligation under the lease, there may be justification for the tenant to reduce its rent commensurate to the service or the maintenance that's being withheld. Same thing with landlord repairs. If your lease is structured such that you have future tenant improvement allowance that's going to be paid out at a certain period of time, if landlord has tipped its hand that it won't be paying that because it doesn't have the funds for it, again, that may be providing some justification for a tenant to unilaterally attempt to modify its lease obligations or even terminate the lease. And the final slide for me, what's going to happen upon termination. The risk here is if you attempt to terminate or modify your lease obligation without having renegotiated an amendment to your lease with your landlord, what are the potential concerns? Acceleration of rent, we discussed that. A tenant could be on the hook for all rent obligations that are going to come due throughout the remainder of the term of the lease, discounted to a present value. Again, there's some enforceability issues with a landlord attempting to enforce that provision, but it's at least a concern for the tenant. Landlord assumption of tenant obligations. If tenant says it's not going to continuously operate the premises or what have you, landlords can assume certain tenant obligations and attempt to charge back their cost for that. Guarantor liability. A tenant can attempt to terminate its lease or abate its rent, and they may even be justified in doing so. There have been some cases in which guarantor liability, though, depending on the language of the contract of the guarantee, is that the individuals who are personally guaranteeing the lease obligations, regardless of whether a tenant is justified, there could be an independent obligation of the guarantors to continue paying the landlord. So if you're a corporate or a company tenant, attempting to terminate your lease may be a small win with a grave loss at the back end. And then finally, if in fact you do terminate, and whether it's justified or unjustified, it's certainly important to put the landlord on notice of their duty to mitigate and attempt to put new tenants into the space in order to attempt to mitigate the damages that they will suffer by not having a tenant paying rent and occupying the space. So with that, I'm going to turn it over to Ted and Andy for a discussion of environmental considerations.
Thank you, Ethan. This is Andy. So what Ethan has talked about up until now is these are the general provisions that anybody needs to think about whenever they want to exit a commercial lease. What Ted and I are going to talk about now is a very specific consideration that dry cleaners have to think about at the time that they're going to exit a lease, that you might want to get out of your lease, because before you can get out of your lease, there are other provisions that may come into play. In virtually every lease, commercial lease that you look at, there's going to be some form of obligation that you return the premises to its original state, or normal wear and tear accepted. You know, the changes and modifications that are intentionally made are often included, but there's a clause that's often inserted in the leases called a no waste clause, that you can't end up contaminating the environment, damaging the walls, impacting the structure of the building, ending up with mold, all these kind of things. They would be considered waste of the building. And so if you are getting ready to exit the lease, you've got to look and think about yourself as a dry cleaner. What are the potential long-term obligations that I might have that might not otherwise be there? And the primary one, of course, is that dry cleaners, particularly ones that operated for a long time, often used PERC, as we all know. And, I've got a canned speech that I give to people who don't know about PERC and how it moves through the environment and things like that. And we'll talk a little bit more about it. But you guys are all dry cleaners, or most of you are dry cleaners, and you understand that, PERC has its purposes, but has the danger of being a contaminant if it gets into the environment. And if that happens, you've got potential liability under these no waste clauses in the lease. Ted, you want to take over on the statutory liability that may also arise?
Sure, and as Andy says, in addition to your lease obligations to your landlord, both Wisconsin and Minnesota, as well as under federal law, there are statutes that create liability for those who own property that is contaminated, for those that cause the contamination. In Wisconsin, we have what's known as the spill statute. In Minnesota, there's what's known as MRLA, which is the Minnesota Environmental Responsibility Liability Act. And that's sort of patterned after the federal Superfund law, which was, of course, created to deal with sort of these major hazardous waste sites that arose that came to light back in the late 70s and early 80s. But that law still applies, as do the state laws, to small operations like dry cleaners where there's contamination. So it applies to those, the owner of the property, which means the landlord is subject to these environmental liabilities. The person the party that causes the contamination is subject to these responsibilities. And that responsibility doesn't really matter if you had any fault or not. It's a strict liability. And it's also what we call in the business joint and several liability. So one party who may have even had a small contribution to a contamination problem can be, by the government, can be held 100% responsible for that. Now, you may have rights and remedies against other parties, but in regards to the liability components of this, it's strict and joint and several, and applies to both the tenant and the landlord. And so we can go on from there. Why don't we go on to the next slide?
And Ted, the joint and several nature of it, that arises from, generally speaking, because the landlord is the physical owner of the property, correct?
Yes, I mean, it's the owners and operators. Usually the current owner and operator is almost always liable. And then those who operated at the time that the contamination occurred, or who may have been engaged in activities that gave rise to contamination, can also be responsible. But by meaning joint and several, it means that all those parties can be responsible, but the government can pick any one of them that they want to go after. Typically, in Wisconsin, for example, I mean, the Wisconsin Department of Natural Resources will generally look at the party who is the causer of the contamination. But if that party isn't there, they will go after whoever happens to be there who may have had some connection to the property.
So, as Ted was saying, this is a strict liability statute and a strict liability regime. And what we've learned over the years in working with dry cleaners is that the contamination, it isn't, no one's intending to contaminate when they operate their dry cleaning machine. You all know that. None of you were doing that. What we've learned is that, the general operation of a dry cleaner, particularly one operating before, the late 80s, early 90s, when they were operating, usually you were using a transfer machine at that point in time. And like I said, usually I have a long explanation of how a transfer machine works, but I don't think I need to do too much of it at this point. But when you were taking those wet clothes out of the washer and moving them into the dryer, often there were what we've deemed sort of drips and dribbles. There were little amounts of PERC contaminated water that fell off and hit the concrete, hit the floor, made it through. PERC, for precisely the reason that it's a good cleaning agent, its ability to get inside the water and sort of get through the fabric, that is what makes it difficult environmentally because it moves very well through the environment. So very small amounts of perk can result from these drips and dribbles and just general operations, can result in noticeable and difficult to deal with environmental contamination. The other places you will often see that the contamination could have arisen is how did you deal with your filters? Did you put them in the dumpster in the back? Did you the diatomaceous earth, the clay filters that you did when you bumped them, did you take that and put it in the dumpster? Did you have any spills that occurred? Sometimes it'll be as simple as there's somebody spilling because they're transferring perk from a 5-gallon bucket into the machine, and there are some minor spills that occur. Sometimes it was somebody from a chemical delivery company that left the hose running a little too long and overfilled the tank. These are all ways in which the contamination can have gotten into the environment. But once it does, then, and once you know about it, then obligations arise that you need to deal with.
Sure, and I'll talk a little bit about that. And just one additional comment sort of what Andy is saying is oftentimes people don't even know that these things are happening. I mean, it can spill onto the floor, get into a crack, get into the subsurface. So you don't even know, people don't know that this has already happened or is happening routinely. It can get into a sewer line, there could be cracks in the sewer line. Nobody knows. So oftentimes what we're facing, especially if a tenant's looking to leave a property, is it may only be discovered at that time for the first time because people start to look around because they know of these sort of historical issues. So just in general, we should talk a little bit about sort of the cost and why this is a big issue is because the cost of dealing with an environmental investigation for a dry cleaner can be costly. You basically have to look at what the extent of the contamination is and come up with some remedial plan to deal with it. And over the years, the cost of doing that has increased because there's what we deal with now a lot are vapor intrusion issues that come up from dry cleaners because it's a very mobile, both in the air as well, and can volatilize and get into spaces, and so it can travel along sewer lines. So it can affect neighboring properties. We've had neighboring houses, we've had neighboring spots and strip malls. All have had to be monitored, sometimes remediated for this. So and Drew will talk a little bit about this before, but for example, Wisconsin has this dry cleaner fund that originally had a limit of $500,000 to do cleanups because that was back in the 90s when this was created. That was thought to be a reasonable amount of money. Well, it turns out that because of what we've learned more about how this stuff moves, it oftentimes is not enough money to handle. And it can also, like I said, it can just dealing with it can disrupt your own operation. We've had properties there had to be excavations within the structure itself, within the footprint of the dry cleaning building. It's disruptive to the neighboring properties because sometimes they have to go in and there has to be testing and monitoring done for adjacent properties. And sometimes the issue here also is that it can result. You may be the current operator of that dry cleaner, but it may have been that the prior operator may have actually been a large contributor to that, but you don't necessarily know those things and it's hard to figure out where it came from. But as long as this sort of joint and several liability issue is there, even a small contributor can be held responsible for sort of the big responsibility. And that has to, without regards to sort of the fault questions there. So I think we can go on. Do we have a next slide here? Is that Drew? Is that up to you now? Are we?
Yes, we're on to me. Thank you. I appreciate it, guys. So I'm going to be talking today about some alternative options for funding if environmental contamination issues are found. So obviously one of the forms of funding would be state dry cleaner remediation funds. We know that both Minnesota and Wisconsin have funds dedicated to dry cleaners. I think there's about 13 states in the country that have or have had funds specifically devoted to dry cleaners. And while each is different in their own right, they have a lot of similar concepts. Like Ted was saying, they usually have caps on the amount of money that can be used. Typically, there are deductibles that have to be paid to be able to use the money. And then funds usually require annual registration fees or surcharges on dry cleaning solvents as a way to sustain those funds. And while there's no doubt that these programs have helped hundreds of dry cleaners all over the country, we are beginning to see that some of them are running out of money. We've talked to a number of dry cleaner funds in the Southeast and the Southwest, on the West Coast, that are considering sunsetting their funds. They're working on legislative acts to try and extend their funds to get more money. Some of the funds are years out from reimbursing their members, and regulatory agencies are not slowing down on the work that is required at those sites to get them to closure. So having historical insurance as an option to fall back on, it really could be an alternative option to explore. So we've worked with dry cleaners who are members of funds. We've helped them locate and use their historical insurance policies. And when at all possible, we try and keep our clients eligible for fund monies should they need to fall back on it. But we typically try and use the insurance first and foremost to fund as much of the cleanup as possible. So when dry cleaners come to us with that looming possibility of environmental contamination, we always recommend looking into insurance as a form of funding for environmental investigation and cleanup as the first and foremost step. And this is the case no matter what stage of the process you're in, whether you were just served a letter from pollution control or from the WDNR. Maybe you've received a notice from your landlord, or perhaps you're just preparing your exit strategy and looking to be proactive in anticipation of this type of situation. But the goal of locating historical insurance first is to minimize your out-of-pocket expense. So the type of policy that we're typically looking for is your commercial general liability policies, or CGL policies. These are your normal everyday business policies, and they are what you would have held to insure business owners against claims for property damage and bodily injury. A lot of people wonder how it's possible that new claims can still be made against old policies. So first, you should know that these policies don't expire. CGL policies that we're interested in are occurrence-based, meaning they don't expire if the damage has happened within the policy period. Also, we're looking for policies that predate any absolute pollution exclusions. We typically see that show up around 1985, 1986. Sometimes, depending on the insurance carrier, you might see that a little later, but generally speaking, 85, 86 is when that shows up. It's also important to note that CGL policies written prior to 85 or 86 usually do still have pollution exclusions in them, but those exclusions contain a clause that created an exception for sudden and accidental releases of contaminants. And that exception is considered ambiguous by many courts when they read the word sudden broadly, and so then it does provide coverage. So if you are unable to track down your own policies, there's always the option of using insurance archaeology to assist with that. Insurance archaeology, by definition, is the practice of locating and retrieving the proof of the existence, terms, conditions, and limits of lost or destroyed insurance policies. So when you're engaging with an insurance archaeologist, it's not always that they're going to be able to track down a full policy. Many times what we're looking for is just evidence that a policy existed. So this could be canceled checks, cancellation notices, declaration pages, binders, but really anything that might show policy period, policy limits, policy numbers, and of course who the carrier was. We get asked all the time whether or not there's a database or a website where we can just type in a name and find those old policies. And while, gee, that sure would be great, that really just isn't the case. So insurance archaeology projects really have a lot of moving parts, and our insurance archaeologists leave no stone unturned. So while many of the methods for locating historical insurance policies are proprietary, to give you a little bit of an idea of what to expect and what they do, so first and foremost, if physical records are available, that's where they're going to want to start. In fact, we recommend that everybody holds on to as many old business records as possible. I know that it's customary to toss out your old business records after about 7 years, but if you do have anything in storage, whether it's in an attic or a basement, or maybe it's in an old filing cabinet, Even if you think it's trash, don't throw it away, because if you have anything at all, you'd be surprised what kind of information might be in those records that an insurance archaeologist would find valuable. So something that looks completely irrelevant to you could be a good lead for an insurance archaeologist to discover coverage for you. Another thing is that, it's not, even if you do have, even if you have thrown out your old records, that's not to say that it's impossible to locate old policy information if you have thrown those out. But if you do have them, do hold on to them. Some other things that insurance archaeologists are going to do, typically it involves personal interviews, whether that's with current or former stakeholders in the business. They also will review public records. And as I mentioned before, when looking at insurance archaeology as an alternative or supplemental funding source for cleanup, an insurance archaeologist should be looking for not only your own, but also for policy information for any predecessors when applicable. So policies for deceased owners or bankrupt entities, those can still hold value and can possibly still be used for the purpose of environmental cleanup. And so lastly, we've got a couple of takeaways for you. So be prepared to show the economics of your situation, to consider the potential liabilities, and to think about how those liabilities might be satisfied. Know your lease and proactively engage your landlord. And lastly, conduct insurance archaeology to locate old policies and make claims for coverage. And so without further ado, if you guys have any questions, please go ahead and type those in. I do have a couple here already. I am going to ask the first one. So are there different considerations for if you signed your lease as a DBA or if you signed as an LLC?
Yeah, I can take that one, Drew. Thanks. Certainly, having a corporate or a company structure as the actual tenant of a lease is certainly going to provide a liability shield. There are potential ways in which parties who are making claims, whether that's a landlord or a third party, can attempt to enforce liability against the principles behind a company. But generally speaking, the company structure and the corporate structure will provide a fail-safe liability shield between the personal assets of the individuals who own the company and the actual company itself. And so that may be a potential consideration, again, if times are a bit tough and there's a question whether or not the lease is going to be potentially terminated due to economic circumstances, whether or not a tenant may be more willing to do that because there's no personal guarantee associated with the lease, and anything that could be recovered would have to be recovered out of the company or the corporation. Again, that might be a drastic measure to take and a reason to do so. But again, the liability shield is a legitimate liability shield, and anyone trying to bypass it has to be put to a pretty high standard of proof in order to do so.
But if you're doing business, Ethan, as a DBA and you sign, as your personal name, doing business as, that's functionally the equivalent of signing. I mean, there's no difference between that and signing on your own, correct?
That's correct. Yep. Unless you've later assigned it to an actual corporation or a company. If it's a DBA, that is simply a name that you're operating to the public with, but you are personally liable on that.
Yep.
All right, Ethan, this is another question for you. Have any small businesses, i.e. retailers or dry cleaners, been successful in pursuing the frustration of purpose doctrine?
I have seen a couple. Historically, the answer is yes. I've seen some cases actually stemming from World War II. I don't know necessarily about dry cleaners, but retail tenants who certain restrictions that were put in place under emergency wartime powers, in which those governmental restrictions defeated the essential purpose of the lease, in which tenants were successfully able to terminate their lease or to modify their rent obligation. The current round of litigation, most of which have not concluded yet. Cases Andy and Ted would probably tell you, take a considerable amount of time to process through the courts, and a lot of them haven't concluded yet. I will say anecdotally, I've heard of cases in which folks are trying to reduce the amount of rent being successful, but actually terminating the lease based on the economic effects or the governmental restrictions. Those have been somewhat difficult to prove on tenants' behalf, especially if there are alternative pathways for tenants to take in order to provide revenue. For example, for a dry cleaner, if they're able to deliver the services, even if folks can't come to the premises, that may still be a window of revenue sourcing that will not defeat the total and essential purpose of the lease contract. So I think landlords have the upper hand here based on the way the leases are drafted, the force majeure provisions that are in there. But from the perspective of a tenant, if you're making moderate and reasonable concessions or asking for moderate and reasonable concessions for rent, those have been moderately successful. And it also, if the landlord's being obtuse and not working with you on this, I think that certainly doesn't help them if they go into court. So asking for a reasonable rent reduction, I've seen a lot of folks be successful with that.
Thank you, Ethan. I've got another question for you. Have you seen any businesses be successful in recovering money from their insurance company due to a loss of business from COVID?
The answer is right now, in most circumstances, the business interruption insurance litigation has been generally unsuccessful. There is a case down, I believe, in Florida, in which a tenant, it was a federal case, I believe, in which a tenant was successful on doing that. What has caused a problem is most courts are reading that there needs to be what we call a physical loss that's actually incurred at the premises before business insurance is provided. There are legislative efforts that are underway in certain states to attempt to expand how the policy is read. That in and of itself is going to have issues as to whether or not states are able to retroactively change the contracts between parties. So there's a lot of this litigation isn't going to be settled for perhaps years. I think the point to take away from it is, one, make the claim, and if you have that policy, and when you receive either the denial or if it starts the line, you get an approval of the claim, great. But if you receive the denial, then it may be time to potentially at least seek legal advice as to whether or not it's worth pursuing at that point. So it's been limited success, but it's certainly not been unheard of.
And I'll just add to that real quickly, because we do a fair amount of insurance coverage work, and oftentimes it's not purely just environmental related. And I was actually talking to an expert that I use in some cases, and who's testified in regards to some of these business interruption cases. And I think there are some good arguments out there, and there is a little bit of traction. What that gives the party is some leverage with regards to their carrier, that they have some risk, and oftentimes that results that can lead to at least a compromise of a claim, which is still better than nothing. And so I would echo what Ethan's saying. If you have business interruption insurance of any sort, the claim should be made, and then kind of react to what the carrier does in response to that claim.
Thank you, guys. And also, my apologies. We also have Rob Hoverman as part of our panel to answer questions. And we have a couple that are a little bit more environmental in nature. So if I could introduce Rob Hoverman from EnviroForensics. He is the director of our Wisconsin office. Are you here, Rob?
I am here. Good afternoon.
Thank you for joining us. So another question is, do tenants typically want to test their new spaces to verify if there is no contamination there? Go ahead.
I'm not sure if that's a typical question, but I think in terms of a due diligence to protect yourself from potential contamination caused by somebody else, it's a good idea. Certainly doing a phase one transaction screen sets you up to understand who may have been there in the past. And then if you identify someone such as a dry cleaner or other user of chemicals of concern, testing may be appropriate.
And let me add to that, you know, it also gives you an opportunity to negotiate then with the landlord. So you get Rob or somebody to come in and do that phase one and you realize that there is a potential that the site could have contamination on it. You can now say to the landlord, okay, look, I'm still interested in taking the space. However, we need to add a clause in here that if at some point in time contamination is detected, I'm not on the hook for it. And those clauses can, generally speaking, be, you know, as long as you're not the owner of the property, are generally enforceable.
Next question actually kind of goes in line with that. Is it possible to date contamination to pinpoint former tenants if my landlord tests at the end of my lease?
I think anytime you're trying to pinpoint the timing of a release, it becomes very difficult. The science on that is very nuanced and often leads to very long and expensive legal battles, which perhaps Ted or Andy might attest to a little better than I. But I would say that's a very difficult notion to pursue.
But Rob, are there markers in the environment that can at least give an indication as to whether or not the contamination is likely to be young or old, without being able to be precise, but at least give an indication?
Sure, certainly if we're talking about, say, perk at a dry cleaner and you have, you know, testing that comes back and there is only perk found in the environment, that might suggest that there is a newer release. Whereas if you have perk plus several of the breakdown contaminants, that might indicate an older release. Does get complicated, but certainly that's an initial marker that you could go with.
And I'll just add real quick that, I mean, there are some things in terms of the nature of the regulations that have been in place with regards to handling of hazardous materials has changed over time. So it's certainly more likely, you know, that earlier operators would have been a contributor to contamination. And also there's sort of the how long it takes for it to move through the environment. Because oftentimes when you're making an insurance claim for these kind of, you have to pinpoint, at least try to make an approximation when the contamination that had occurred during the policy period. And so oftentimes we have to sort of go through an analysis of how long it took it for a contamination to travel from point A to point B. And that can help also identify when releases more likely occurred. So there are things that can be done, but chemical tracing, I mean, that's what Rob was talking, that's little used just because it's so expensive to use that as the primary driver of the analysis.
And Rob, you kind of just touched on this on the second to last question, but if I'm considering getting out of my lease, what do I need to do to see if I might have an environmental problem?
Certainly, some initial testing can provide some quick indicators whether or not there is the potential for a larger release. You know, a quick soil sample, perhaps subslab or soil gas vapor sampling will give you those quick, inexpensive indicators whether or not there's a problem.
And
There's also though, oh, go ahead, Drew.
Oh, I was just going to say, and also if you are considering exploring the potential into environmental contamination to, as I mentioned before, look into the possibility of whether or not you have insurance, or if an owner or operator before you had insurance, to help offset costs should contamination be found.
Yes,
Ted, are there legal reasons, Ted, and I'm guessing this is probably right where you're going to go, but are there legal reasons why you might not want to test as you're exiting your lease?
Well, yes. I mean, those statutes that I talked about earlier, basically, once you know you have contamination at your location, there is an affirmative duty to give notice of that to the government, and the failure to do that could create even more problems for you. So what we would often recommend is, number one, before you look for the insurance, because if you do find something, you'd like to know that you got a potential source of recovery there. Because once you do get notice, you send that notification to the state or the federal government. They send you a letter back saying, okay, thank you for the notice, now you're responsible. That letter of responsibility is basically the equivalent of a lawsuit that's being filed against you for purposes of insurance. You take that letter, that then goes to the insurance company. They then have an obligation to step in and defend you from that investigation and to indemnify you. Now, there's issues with all of that, but that's the driver behind why you want to look for the old insurance, is because that letter from the state telling you to clean up is the equivalent of being sued, and you want to be defended from that suit by your insurance company. So there are reasons why you don't want to look, because you may find something and it creates an affirmative duty. On the same token, if you are, sometimes you can look, and if you are going to do that, you may want to talk to a lawyer about trying to protect that information as much as possible beforehand, before you just go do stuff. So there are issues. They work for both sides, both landlords and tenants, new tenants, old tenants. Everybody has those same issues when it comes to looking for contamination.
Any more questions? We don't have any more just yet, but maybe there's a couple of, give it a quick second. All right. Well, I want to say a giant thank you again to MCA and to WFI. Thank you, Ethan, Andy, Ted, and thank you, Rob, for joining on this Q&A panel. I really appreciate it.
Thank you.
Thank you.
Thank you.
And just so everybody knows, you should be receiving the recorded version of this and email possibly by tomorrow. So thank you, everyone.